in the matter of the marriage of Benjamin H. Bravo and Monica O'Rourke Bravo. It's case number 2024 DM 309. Each party, Benjamin and Monica, appear by separate Zoom. Court conducted proceedings in this case on February the 12th. The court had a rather extensive set of docket notes, which I'll just read. At that time, Monica and Benjamin both appeared by Zoom, Benjamin from California. No action was taken on Monica's parenting time motion. Court notes that the registration of foreign judgment was not timely opposed. Kansas court has not made a decision as to whether Kansas accepts child custody jurisdiction to modify custody or parenting time orders. There's a California hearing. Judge Hamilton, Division 303, Fresno, California, set for March 18th, likely to be postponed on dad's motion to have primary residential custody. For now, California maintains jurisdiction. Court order temporary to be provided to court for consideration and possible UCCJEA conference and determination. Kids have lived here with mother since November of 2023. There's a move away order granted in California in September of 2023. Kids apparently in Andover schools. Her California restraining order expired and the review hearing was set for today. All right. After all that, we are where we are. I'm curious, what happened in California during the scheduled court proceedings for March 18? Monica?
Your Honor, there was an ex parte hearing at the beginning of March to request an extension for the trial in order for my lawyer to properly subpoena witnesses, since all of the witnesses for this case are in Kansas and require a little bit of extended time to get all of the subpoenas together for that. In light of that request, the judge postponed the trial or continued the trial to May 28th and 29th. There's 2 days, 2 whole afternoons set for the trial and on May 28th and 29th.
All right, Benjamin, is that your understanding as to what happened?
I wasn't present for the hearing, but there is a court date set for May, I think those 2 days right there. So.
All right. Monica, are you comfortable with the California court retaining jurisdiction and making the determination regarding any issues which may exist?
Your Honor, there's currently a motion and temporary order, which is what the California court is hearing in May. It is my understanding that because that order has already been, because it is already in process in the courts in California, that it's required that they finish this process for this current motion. If that is not the case, my preference would be to move the jurisdiction to Kansas immediately. If that is the case, that the current motion needs to be decided on in California first, then I would like to have the jurisdiction moved to Kansas following that, the conclusion of that motion.
Well, at that point, that could possibly change the physical custody of these children from Kansas to California, couldn't it?
Your Honor, that's actually not what the current conversation is regarding. The kids currently, I still retain, so let me back up. There was a temporary order put in place in January, and that in question at the hearing in May is whether or not that temporary order will become permanent, not a change to that, not necessarily a change to that order. Currently, the temporary order is that I still retain sole legal custody. We have shared physical, in which case the children's primary residence remains in Kansas, and Mr. Hernandez has visitation. It was simply just an increase in the amount of visitation, not that.
That's not the situation, Your Honor.
Let her finish, Benjamin, because I'm going to address you in just a moment.
Okay.
Go ahead.
The current order does state that the children's continued residence is in Kansas, and that the order is for them to fly to California 12 times a year, spending 71 days there. There's a lot of question around how it's written, and this is a big part of why I'm asking for the jurisdiction to be moved to Kansas, because the California judge wrote the orders in such a way that is very incongruent with Kansas laws and Kansas school districts and this Kansas school calendar. So the order will have to be changed in some way. It's incongruent and not reasonable to follow the way it's written, because it is written from a California court based on California schools, even though the kids are permanently residing here.
All right, Benjamin, thank you for your patience. What is your understanding of what's
The-
going to be contested?
So when
in-
when I filed the paperwork, the boys were being homeschooled, and so the court order, that's the temporary order that's in place right now, it has us exchanging every month. So I have the odd months and she has the even months, and so we split like summer times and spring break. That's in the plan as well. And I think they did that because they were in homeschool when I submitted the paperwork. And so this last year, Ms. O'Rourke decided to change up the school situation so that she could attempt to continue to maintain that custody. And so one of my boys is in permanent school now, and the other one's still doing temporary. He's doing homeschooling, the other one. So that's why both of my boys have been homeschooled most of their lives. So that's why the court order was issued in such a manner, because they haven't been around me the last few years like they were before. And so the court addressed that issue because they have been homeschooled. And so they were trying to give each one of us 50-50 physical custody so that we could both be present in their lives. And that's why the order is written the way it is.
I'm sorry, Your Honor. I'd like to clarify some of the inaccuracies that were just stated. The children were not in homeschool when the motion was originally filed. The children were enrolled, pre-enrolled in Andover schools back in May, and this motion was not filed until July. I'd also like to take your attention to the current order that Your Honor has a copy of. I sent it during our last hearing. Under the order 3.02 states, commencing with the date of the signing of this court order, the children shall reside primarily with the mother in Butler County, Kansas, except for the specific periods of time outlined below. And every other month order that Mr. Hernandez is speaking of is that he is to see them for one weekend every other month.
That is not correct.
There are additional inclusions in that order for them to spend time over holidays and during the summer as well, usually in a 1 week increment. But point number 3.02 does clearly state that commencing with that the children's primary residence is still maintained in Butler County, Kansas. In which case I am currently asking for Your Honor to request jurisdiction be moved to Butler County, Kansas, since these children will, regardless of the outcome, this is the current order in place right now. The hearing is to contest that. The hearing coming up in May is to contest this order. I am the one contesting it. I'm not contesting that their residents continue to be in Kansas. I am contesting the amount of time and the methods that visitation continues. I do believe it is important for the kids to continue to visit their dad. It's contesting of it is simply that they like I said before, the way that the order is written is very incongruent with Kansas, the way the structures are here in Kansas. And that is my only request. And so if it is possible to have the entire motion moved to Kansas and have your honor hear this order be contested here, that would be fine with me. And if that's not possible, then let the California court finish this portion and then have it moved here, because the judge has already ordered that the kids' residence has been and will continue to be Kansas.
That's not the situation. I'm not really sure what order Miss O'Rourke is reading, because that's not the court order that was granted. Because there's a 3-phase process to that new order, and I just completed the 3rd phase by visiting my sons in March of this month, and I'm supposed to get them every other month. So they gave us both 50-50 physical custody of our sons. I'm not really sure which order Miss O'Rourke is reading from, because that's definitely not the wording that I'm reading in the order at all. And this is one of the reasons why I think the Kansas court should not take this case over, because Miss O'Rourke has now been willing to co-parent every single situation that she can figure out to put up to make a wall between me and my kids. This is just another situation. By transferring over to Kansas, she's able to maintain that control, which she really likes. And she's able to put up just another barrier in between my relationship with my sons. I've completed what the court has asked me to do, and I'm asking the Kansas court to not take take jurisdiction of this case, because I feel like Ms. O'Rourke is just putting another barrier between me and my sons, and this would not be good for Ben and for Sam. They want to be around their father. They've specifically made that clear, and I hope that the Kansas court will understand that I have been present, and I will continue to be present, and I hope that the Kansas court understands that they need their father. That I'm just as important as the mom in this situation. If you see me and my kids interact with each other, you will see a completely different story than what Ms. O'Rourke has shared in the court hearings. She's been able to get away with legal maneuvering through the legal system to put up to basically legally harass me in my parenting ability. And I'm asking the Kansas court not to take this situation over, because the what she just read, that she said that there's 12 weeks, I believe she said, 12 weekends that I get to visit. That is nowhere in any of that paperwork. It says that I'm supposed to get them in May. She's supposed to get them in June. I'm supposed to get them in July. She's supposed to get them in August. I'm supposed to get them in September. We're supposed to split the holidays, the spring break, and the summertime. I'm not really sure which court order she's hearing or reading, because that's not the court order that I received from the Fresno County Court.
I have before me what's called a family law findings and order after hearing, apparently issued January 15 of 2025. It makes reference on page 2. Court will adopt the proposed custody and parenting time order as a temporary order until the contested hearing. See temporary order, child custody and parenting plan filed today's date. That is not attached to this order.
Right. I think
I
you
don't know
just
what
got the
it says.
minute hearings, or the
Your Honor, I already, I did send you that order the last time we met. I can resend it again if you'd like.
This temporary order, which is supposedly an attachment to the order that I have.
Correct.
Okay, well, I don't have that before me. Let's put it that way. So I don't know how to resolve the dispute between the two of you as to what that temporary order says. It is what it is. And I'm not going to advise the parties to go against it. All right. When did the children establish residency in Kansas?
In November of 2023.
Okay.
And Your Honor, I did just resend that the actual orders that of which I was referring to when I read 3.02. And the portions that Mr. Hernandez is referring to are below that. In that same section, the children established residency in Kansas in November of 2023.
Okay. All right. November of 2023. And then Mr. Bravo Hernandez, you filed something in California to reinitiate proceedings there. Is that correct?
Right. Yeah, I've been in the process of
Do you know
reinitiating.
the date that you filed your motion?
I think it was like in June. I want to say June or May of last year.
Your Honor, it was in July, the end of July of
July.
2024.
Okay. One thing that is somewhat disturbing from a child custody jurisdictional standpoint is the court's finding that was apparently made in January that California is the home state
Right.
in this case and continues to have jurisdiction.
Yes, they said
I
that.
fail to see that the facts supported that finding. I don't know how that finding was made. Kansas was apparently clearly the home state of the children as of not only January of 2025, what that would have related back to sometime during the summer of 2024. Generally, there's a 6-month establishment of home state jurisdiction. If the children have lived continuously within a certain state for 6 months, that new state has child custody jurisdiction, what we call home state jurisdiction. And if there was no motion pending in California after the children had been in Kansas for 6 months, I don't quite see what the basis was for a finding that California was the home state, because it wasn't. The children weren't even living there.
I think we've been in legal proceedings since she moved away. To be honest with you, that's why the California jurisdiction they took effect.
Your Honor, that's not true.
I mean, I'm just getting
The
the
final
impression.
legal proceeding was the move away order when we moved out here in November of 2023. There were no pending legal proceedings until Mr. Hernandez filed the motion in July.
Okay, all right. I guess all I'm saying is I'm struggling with the concept that California is retaining jurisdiction as home state. Now, they may have some other basis for jurisdiction, but if they're relying on home state jurisdiction, I'm just not sure where that finding comes from.
Right.
And if that was the basis for jurisdiction, I'm not sure California has it. Kansas very well may. All right. Well, something that the California court has not contacted this court has not initiated contact with Commissioner Hamilton pending the outcome of the March hearing. We now know what that was, and that was establishment of a trial date in May. I think this court is going to have to initiate contact with the California court. We're going to have to sort out this issue of child custody jurisdiction. Kansas law, and I'm quite confident California law would also support that there needs to be a conference between the two courts to determine who's going to take child custody jurisdiction over these children at this time.
Your Honor?
Yes, and I understand your position that you don't want Kansas to take it.
Right.
I get the impression certainly that Monica doesn't want California to keep it. So
that's because it's in her best interest. But I was going to ask you,
actually in the best
can you
interest of the
clarify?
children to have
just
custody.
a minute. Just a minute. I'm going to give Benjamin the floor. Benjamin?
Can you just clarify like what that court order allows me to do? Because I think one of the issues here is that we're not able to co-parent, and she is wanting to maintain control, and I just want to figure out what am I able to do in terms of seeing my kids, because that's really what I'm interested in. I'm not interested in dealing with Miss O'Rourke. I'm interested in just seeing my kids, and so I just want to make sure I maintain or understand what this court proceeding, what it allows me to do when it comes to seeing my kids.
Are you talking about Kansas or California?
No, the court order, that temporary order that was was provided to us, because Mr. O'Rourke has a different interpretation of what it says. And according to what I've read is that I can see my kids in May. So they have to be flown out to California. And that's what the court was telling us, that we have to pay half of the ticket for the kids to be flown out. Mr. O'Rourke keeps on asking me to pay for me to travel out to Kansas every single time. And so I just want to get clarification from somebody that's in a legal situation, so that I have a good understanding of what, the next time I'm able to see my kids.
All right, well, I presume this order attachment, which I don't have before me, addresses that. As far as interpretation of it, I would suggest that your California lawyer interpret it for you.
Okay.
I'm not going to be giving either one of you legal advice as to what a California order says. There's no Kansas order which governs things right now.
Right.
That I can construe for you.
Okay.
But you're not proceeding under a Kansas order. You're currently proceeding under a California order.
Okay.
So I think I'll let your attorneys give you advice as to what your rights are or are not under
Right.
this temporary order, which will be in effect at least until the end of May. Apparently,
Right.
trial date, and that's great. But that also establishes the time frame for me to get with the California court, because I have a motion here in the Kansas court, which we really can't further as long as California is entering what could be conflicting orders.
Right.
And I don't want you two to be confused about what state's orders to follow. So we need to clarify that.
Right.
And that will be this court's next step. Apparently, at this point, it's unavoidable that a UCCJEA conference will be necessary between me and Commissioner Hamilton. And I trust Commissioner Hamilton's still going to be the judge that hears the case in California?
Yeah.
Okay. All right. I don't know how often they shift those cases around. I don't know how their system works, but if that commissioner's still staying with it, then that's who I'm going to need to contact.
Okay.
All right. I think I probably have accurate addresses and email addresses for the two of you.
Yes.
Probably
Okay.
so.
All right. Well, when there's an outcome of that conference, I think it's going to be necessary for you two to be notified exactly what that result was. And this court will likely have to take the responsibility of issuing just an order, either confirming or declining jurisdiction here in Kansas. I am curious how the California court thinks they have home state jurisdiction. There may be some facts there that I'm not aware of currently.
Your Honor, under all of the dictates of the UCCJEA, Kansas is the state that would be required to have jurisdiction. I created a motion in California because I thought I needed to create it there to have jurisdiction transferred. And they denied that motion without prejudice, telling me that I needed to have that proceeding started here. That being said, just so you're aware, Judge Hamilton does have documentation regarding this process or this proceeding that I have previously filed in California. So she should have in front of her the reasoning and for the change in jurisdiction to be in Kansas. And again, I do want to note that I did send you the temporary order that is currently in place. And when you look over that order, my primary concern, again, in the best interest of the children, is that it has them missing school for extended periods of time. It has them flying back and forth between Kansas and California multiple times a year. Just creates a very unstable situation for the children. And so when I'm asking the courts, what I will be asking the California court, if If this motion continues in California, or if it's possible to have this motion heard here in Kansas, and abandon that trial to bring it here instead, and continue and have jurisdiction continued here so that the change in order could be heard here. Either way, the primary concern is that having a California court determine custody scheduling, visitation scheduling, when the children's reality is here in Kansas, and it is very, very different. I was a teacher there, I was a teacher here, and they're very, very different places. Just in the best interest of the children to have long-term, we have 7 years left, but who's counting? But longer term, to have the Kansas, a Kansas jurisdiction so that it can be responsive to what their needs are as they develop and grow here.
Your Honor, can I say something?
You may.
Ms. O'Rourke pretty much has limited my amount of time that I can see the boys. But basically, her preference has always been that I be placed on supervised visits and that she have full custody. That's always been her preference. It's always been limited. This is basically another way of doing that, is creating all these hurdles so that she can maintain control. It's not really about looking out for the best interest. If she was looking out for the best interest of our boys, she would not have moved them to Kansas, because they don't have any family in that area. She doesn't have any family support. She didn't look out for the best interest of our boys when she made that decision to move them to Kansas. You attend a soccer game. I was there a few weeks ago to watch my boys play soccer. Basically, there's no one supporting them at these soccer games. If they were to be here in Fresno where they're supposed to be at, my entire family would have came out for the game. And that's like uncles, aunts, nephews, and nieces. They would have came out to support my sons. I don't think it's in the best interest of my sons to live in Kansas, but that decision was not made up to me. And I think in the long term, my boys, it would be more beneficial for my boys to be around me because that time has been limited the last few years. Their mom maintains control physically, legally, and psychologically. She has alienated those boys from their father, and she continues to alienate Ben and Sam just in her ways. For instance, the other day I was supposed to have communication with Ben and Sam on Zoom. I forgot. Instead of her getting a hold of me, she decided that she didn't have any responsibility to communicate with me over talking parents. And so I sent her a message and I said, hey, I'm sorry, I forgot to get on Zoom. I'm on Zoom now. Can you put the boys on? And I didn't hear any communication from her until like the following day. She didn't even respond to that message. These are the types of things that happen quite frequently with Miss O'Rourke. She has pretty much limited my ability to communicate with them. The only thing that she allows me to do is to communicate through the court order, whatever has been granted, and that's not necessarily in the best interest of our sons. Our sons, if you see them with me, they want my attention. Like, they want to communicate with me. They want to hang out. We play nothing but sports and enjoy our time together. Yeah, it's just been a big situation where Miss O'Rourke, she seems like she's doing it in the best interest. She communicates really well, but when it comes down to it, Miss O'Rourke is not doing what she's supposed to do as a mother. And me as a father, I don't think it's in the best interest of my sons to be away from their mother. I think they have that good relationship with her. but I don't think what Miss O'Rourke is doing in terms on the other side of not allowing me to communicate with them, not allowing me to see them, is in the best interest of our sons. And this might not be present now, but in the future, it's going to affect them psychologically. And Miss O'Rourke knows this because she's an educator, and she knows way better than what she's doing for those boys right now. And I hope that the Kansas court understands that this is more about control. This is not about actually looking out for the best interest of our sons. If she was looking out for the best interest of our sons, she would have never moved them out of Kansas.
Mr. Bravo Hernandez, do you think it's in the best interest of your boys to have their educational programs disrupted every other month by being sent to California and not being in school?
The thing about that is that they have been homeschooled most of their
Okay, but-
lives.
Okay, regardless of what the past was, isn't the current reality
Right.
that they're, for this last school year, they've been in a structured school situation?
I don't think that it should be they should be disrupted, like the educational flow of their program should not be disrupted. I don't think that's in the best interest of our sons, to be honest with you. But the other side of that is I don't think it's in the best interest of our sons to move them to another state where they're going to be separated from their father. I was separated from my father at a very young age.
All right. I guess I'll stop you there, because if
Go
you're
ahead.
obviously, we're not arguing custody of these boys
Right.
today. That
Right.
matter is not currently before this court. What is before this court is a possible issue as to whether this court should take over child custody jurisdiction and then hear this case.
Right.
With all of these factors being considered. If you're attempting to suggest to this court that Monica has engaged in reprehensible conduct that I should consider in declining of jurisdiction, nothing you've said in the view of this court constitutes reprehensible conduct. In fact, even the move away was done pursuant by court order in California. She sought proper permission from the court to move the children away. So
Right.
I don't know that we've got a reprehensible conduct case here when it comes to whether or not Kansas should exercise jurisdiction. And I'm not
But,
going to
Your Honor-
decide the custody case before I decide whether I have jurisdiction to do so.
Your Honor, I might not have been able to prove it because I don't have an attorney that there has been reprehensible being dishonest in the court system. But in my opinion, the facts of the situation are a little bit deeper than this, and I know that you can't take it. You can only look at what's been judged on. But if you look deeper into the situation, there has been a lot of dishonesty in the situation to be able to maintain control, and this is what this case right now is currently about. Moving jurisdiction is just another control issue, and I don't think it's in the best interest of our sons. But that's not. I can only control what I can control.
Good. All right, the court will take the issue of Kansas child custody jurisdiction under advisement. It is the intention of this court to set up the conference with Commissioner Hamilton in California. We'll discuss the jurisdictional bases in California and Kansas and make hopefully an appropriate joint determination as to what jurisdiction is the most appropriate forum to hear any child custody or parenting time schedule disputes which currently exist between the two of you. And obviously with the best interest of these boys in mind.
Right.
So I'm going to set this case for review hearing prior to the California trial date. So I would intend to notify you by written order what the outcome was with my jurisdictional meeting with the California judge prior to this time. I just want to make sure I have a date on the calendar to work towards. The date, 28th and 29th.
I'm double checking those dates for you. Sorry. I'm sorry. It was it is the 29th and 30th.
Oh, okay.
Yeah.
Right. I am looking at a date for review on Tuesday, May the 27th. I'll conduct it at 11 o'clock a.m. Kansas time. Which I think it'd be 9 o'clock in the morning in California, wouldn't it, Mr. Bravo?
Yeah, I had to do some adjustments this morning because I forgot you guys were two hours ahead.
Okay.
The 27th should work. You said the May 27th?
Yes, that's the Tuesday right after Memorial Day.
Yeah, that should work.
Okay. So it'll be 11 o'clock Kansas time on Tuesday, May the 27th. I think for simplicity purposes, we use the same Zoom numbers as last time, Mandy. Now that we've shifted to a different Zoom system, will we have to send another Zoom invite?
We can use the same one.
We can use the same one?
Yes, Judge.
Okay, it'll be the same Zoom numbers then? And we'll look at the case again based on then current circumstances, Tuesday, May 27, 11 o'clock a.m. by Zoom.
Thank you, Your Honor.
Until then, I hope that you two can work together in accord with the California orders in the best interest of your children.
All right.
Thank you, Your
Thank
Honor.
you, Your Honor.
We'll see you May 27th at 11 by
All
Zoom.
right, you too.
Benjamin H. Bravo and Monica O'Rourke Bravo. It's case number 2024 DM 309. There's no appearance from Benjamin Bravo. Monica O'Rourke Bravo does appear. Docket notes from our last court proceeding was from April the 2nd. Both parents appeared pro se by Zoom. The court noted California had set a trial for apparently this week. A UCCJEA conference was needed. Mother desires Kansas jurisdiction. Father wanted California jurisdiction. Court made no orders other than setting a Zoom status conference for essentially today at 11 o'clock. Court was likely to issue a written order following a UCCJEA conference with the California Commissioner. Subsequently, on May 21 of 2025, the court did conduct a Zoom conference with Judge D'Alessandro of the Fresno, California court. A decision was discussed regarding UCCJEA jurisdiction. In other words, who will decide who will exercise child custody jurisdiction. California did not decline jurisdiction. California decided to keep the case for trial out there starting, I think, May 28th, which would be tomorrow. This court would issue a journal entry documenting this. This court did enter an order entitled Journal Entry of Determination of Child Custody Jurisdiction following communication between courts. And that was apparently dated and filed May 21st of 2025. Both parties were notified. Perhaps after receipt of that order, Mr. Bravo felt it wasn't necessary to appear this morning. I wish he would have. However, I think under the circumstances, I understand why he didn't. The real issue before the court right now is what does the court do with this Kansas case? California did not decline jurisdiction. They decided to exercise it at the trial to take place this week. I don't know if there's any real business for this court to conduct. Monica, you're on this meeting. What is your position here?
Thank you, Your Honor. I have two primary questions / concerns. My first question is regarding the judge with whom Your Honor spoke with in California. Judge D'Alessandro has not ever and is not presiding over our case in California. So my question is how it came about that he was the one who conducted the conference and made this determination, because he has not been present at any court proceedings over our case, and he is not presiding over the upcoming hearing on that's later this week.
All right. I note your email that was sent to my assistant back on May the 6th, which specifically identified Judge Samuel D'Alessandro of the Family Law Department. This was from you that informed our court that he was the new judge on the case who would hear it. So naturally, he was the one that this court contacted. I first tried to contact Judge Hamilton, who had handled the case previously, got no response. And then eventually, after receiving your email, the court contacted Judge D'Alessandro, who said that he was bringing himself up to speed in the case. He was looking over the case and apparently did some of that prior to our conference. It was my understanding he was going to be the trial judge. I don't know if it's been reassigned to someone else for the actual conducting of the trial. All I know is it was that judge that I conducted the conference with. So,
Your Honor, that email that I sent you was based on incorrect information that was came from the paralegal at my lawyer's or my attorney's office. To speak very colloquially, the Fresno, California court system, especially the family court system, is a quote unquote mess. They move judges continuously. We have had, I think, 8 different judges hear our case over the course of the last, what would it be, 7 years. And what happened was there's benches by department number, and they moved judges to different departments. So we were previously in department, I think it was 303. Judge Hamilton was the judge presiding in that department. A month or a month and a half ago, they moved Judge Hamilton to a different department, to Department 202. Judge D'Alessandro is now presiding over department, I believe it's 303, which was the previous department. And so the paralegal made the assumption that when the judges were moved, that our case would continue to be presided over in the same department. And so then she notified me and said, you need to let the Kansas judge know that this isn't a different department, or this is a different judge that will be presiding. Which is why I sent you that email. When I spoke with my lawyer last week, it was, and then followed up with the actual court clerk. I personally called the court clerk in Fresno last week. The courts in Fresno moved our case with the judge. So we are now in a different department, but retain the same judge, which is Judge Hamilton. It will be Judge Hamilton that is presiding over our case. Judge D'Alessandro, I would assume, stated that he was catching himself up with the case because he's never seen it before. Additionally, he's not the judge that will be presiding over the hearing that's coming up this week.
okay.
So he has not ever and will not have anything to do with our case. He has never heard it. He's never seen any of it.
All right. Certainly, if Judge D'Alessandro felt like that he wasn't the one to talk to, I trust he would have told me that. He did clearly acknowledge that prior orders had been entered, I think, by Judge Hamilton.
Mm-hmm.
But he did know that you had been through mediation. He knew that you were scheduled to go to trial this week, and that the case essentially was imminent as far as a trial date was concerned in California. And he asked specifically how far proceedings had gone here in Kansas. And I said, well, until the jurisdictional issue was settled, they haven't been furthered at all, which is the truth.
Mm-hmm.
As I understood the applicable law, California first exercised jurisdiction in the case.
Correct.
They were the court of initial child custody jurisdiction. One of the parties still lives there. Therefore, it would appear under our statutory law that we needed to confer. California needed to make certain findings to send it back to Kansas. That we were the more appropriate forum, for example, that we were the more convenient forum. Those findings were not made. From the conversation that we had, that's what I based my order on to document in my file that I'd had the conference and that California did not essentially relinquish jurisdiction to Kansas, though I think he certainly considered it. He eventually declined to do so, that it was that court's decision ultimately, not this one's. So rather than set up a situation where you're doing two trials with potentially conflicting orders, I think the laws of the two states are intended to make sure that there's some harmony and some agreement about who's going to exercise jurisdiction, and it appears that California is going to at this point. So one option the court has is simply dismiss this case without prejudice, because I don't know that there's anything right now that the Kansas court can do or will do. But go ahead. I think you're going to make a statement.
I actually I'm just a question. Did Judge Alessandro give a rationale for maintaining jurisdiction? Because I am aware that the California statute requires that children who have not been residents of the state for at least 6 months, and the statute states that children where the predominance of evidence lies is where the jurisdiction should lie. And obviously we have a trial coming up and every single witness is appearing via Zoom from Kansas because all of the evidence regarding the state of the children is here in Kansas. There is no evidence at all in California regarding the state of the children. And so my question is, on what basis did California determine that they should rechange jurisdiction? Was it simply because there was a current pending motion, or was there more than that?
I don't want to speak for Judge D'Alessandro and his mental processes for his ultimate decision, though I don't think there's any question that the fact that you've got a trial date actually set and ready to go, that both sides are prepared, both with attorneys, I think that was probably a factor in the decision, without a doubt. Ultimately, it was that court's decision and therefore that court's rationale. So I don't really want to speak for Judge D'Alessandro, but only speak for the fact that the Kansas court is not going to be exercising child custody jurisdiction at this time.
So then my follow-up question is, moving forward, we do have a trial. I have an attorney. He does not actually have an attorney for the upcoming trial. And upon the conclusion of that trial, there will be an order that will exist. I am asking, the current orders, or the orders that were temporarily put in place, require that the children fly to California extensively, and that has a very significant effect on their well-being and their lives. And so that is the basis of the trial. Additionally, it should be known that the children have expressed vehemently that they will not board a plane. I let them know that starting in June, they were going to be required to fly to California per the current orders, or per the temporary orders. And they did express very clearly to me that short of putting them in handcuffs and having law enforcement take them to the airport, that they would not be traveling to California. Your Honor should know that the oldest is 13, and he is set to testify at this trial as such. Following the determination that the California court makes this week regarding the current orders, and what I am asking California is that visitation continue to be in Kansas so that the children are able to continue to participate in their regular daily lives here in Kansas, and also maintain a relationship with their dad when he chooses to show up. He was ordered to have visitation in Kansas the months of January, February, March, April, and May. He came January, February, and March, and he has refused to visit the children since then. So there is inconsistency in visitation. There's issues here. The court, I understand fully why the California court retained jurisdiction, because there is the upcoming trial. Following the trial, Judge Hamilton will make a determination regarding custody. For better or for worse, it will be what it is. My question is, following that determination, what process, my children are 11 and 13, so we have 7 more years until, of custody issues. And at what point or by what process would it be reasonable for me to bring this case back to Kansas and request another UCCJEA to change jurisdiction? I mean, in my mind, I guess what I'm wondering is if it's possible, once orders are made, once a determination is made, can we preemptively set up? It doesn't matter what the orders say. To me, it doesn't matter what the orders say. I would like to preemptively set up a follow-up UCCJEA to see about moving jurisdiction here for the remainder. We're not talking like 6 months, we're talking 7 years more of custody. Regardless of whether something is filed a motion is filed to change the parenting time, that it could be established that when it is deemed necessary to make an adjustment to the parenting time order that is going to currently be made now, where that can happen.
To a certain extent, the answer to your question may depend on what the California court does at this trial. Certainly, if the father is granted primary custody of these kids, I can't see a scenario in which Kansas would assert child custody jurisdiction of kids who are under a custody order and living in the state of California. But there are other alternatives that could come out of this hearing that might allow the Kansas courts at some point in the future to assert jurisdiction. However, I'm not in any position to answer your question. Perhaps that would be better addressed to a Kansas lawyer or to your California lawyer,
Okay.
either before, during, or after your trial. I think certainly that lawyer would need to know what the outcome of the California proceeding truly is.
Right.
But what I'm inclined to do at this point is not to dismiss this case at this time. What I'm inclined to do is to leave it open until August the 29th. We have a target in Kansas that civil cases are supposed to be resolved by 1 year. That will be your 1 year from your filing date in this case. I'm just going to grant a stay of proceedings for a period of about 3 more months. We're not going to schedule any more hearings. There's nothing for Kansas to do. Any assertion, a proper or legitimate assertion of Kansas jurisdiction needs to be made by some sort of new motion, depending on whatever it is, enforcement, modification. I don't know what relief would be properly sought. I'm not going to pre-rule on it, but I'll leave the case open for a period of 3 months. If nothing is filed at the end of that 3-month period, in this case, that would properly ask for assertion of Kansas jurisdiction, the court will dismiss this case without prejudice, which means it could be refiled in the future. But I need to get some sort of eventual end to this case, one way or the other.
So then my question would be, in terms of requesting for a reevaluation of jurisdiction, would that be Would the request be made here in Kansas? Would the request be made in California? Do I need to do both?
Better ask to lawyers in those respective states.
I will tell you flat out, they don't know. I have contacted 3 separate lawyers in California, and I've contacted 5 separate lawyers in Kansas, and not a
Okay.
single one could give me any definitive guidance, even after paying them their lawyer fees,
Really?
on
Oh, okay.
how to accomplish a UCCJEA jurisdiction change.
Oh, that's interesting.
It was very interesting and actually quite frustrating, which is because I have been trying to get jurisdiction changed since well before he filed the motion. And because I could not ever get a straight answer from any lawyer in any state, in either state, he was able to file this motion like he snuck in and filed the motion because he knew I was trying to get it transferred. And I couldn't get any legal help to get it transferred.
Didn't he file his motion in California before you filed your action in Kansas?
I had filed an initial thing, and it was in Sedgwick County, and it
Oh.
was filed incorrectly.
Okay.
I had contacted lawyers here. They didn't know how to do it, and they filed it in Sedgwick County, even though I don't live there, and they filed it incorrectly. And so then when it kicked back, then I had to figure out how to file here. So then I filed here and I filed there. I, I guess, I mean, it would be very, very surprising. Even the temporary orders still state that the children's primary residence is Butler County. So the location of their residence is not actually what is in contention. It would be the location of the visitation, because the current orders still state that their primary residence is still in Kansas.
Well, is that
Um,
being challenged in California?
No, it's not.
Okay.
He's
All right.
not challenging their location of residence. He's actually not challenging anything. The orders state that their primary residence is in Kansas, is in Butler County, and that they are to visit their dad in California. And the only thing that is being challenged is the location of the visitation. I am challenging the location for them to be able to, for him to come here to visit them so that they can still do sports, so that they're not missing. Right now, they have them missing 27 days of school a year. I mean, yes, I wish I was kidding. They wrote orders based on a California school calendar, not a Kansas school calendar. It has them missing extensive amounts of school. It has them flying back and forth continually during school. It's just not healthy for them. So the only thing that's being challenged is I'm saying, please follow a Kansas school schedule for visitation, and please have the visitations here so the kids can have jobs and play soccer and have their regular lives. That is the challenge.
Well, it's certainly possible the California court may see it your way. And if so, you'll be comfortable with the California court orders at the end of this trial.
Correct.
That's certainly possible.
Correct.
Um,
I may or may not want to be making a request for a change in the orders, but I do still want to make a request for jurisdiction to lie here so that when the time comes that the orders need to be revisited as the kids get older and what they're involved in changes and all of that this court is the court that then subsequently is the one that hears any further issue.
Look,
So,
you should ask the California court for that ruling, it would seem. That if
okay.
we really want the California court to, at the end of this, relinquish future issues regarding child custody and parenting rights to the state of Kansas, you could ask for the court for that ruling at that point.
So then what I will do is I will prepare an RFO, a request for order, to California for because I did this, but because this motion was already in process, that RFO was denied without prejudice.
Mhm.
She's basically, Judge Hamilton said, see me after the trial.
Mhm.
And also said, maybe you should, actually already had the motion in process in Kansas as well. So I will now refile an RFO and have this revisited. Because this case is already open, then it is my understanding that I don't need to refile an additional motion here.
No, actually you do.
I do.
Where I'm leaving things is that I'm just going to grant a stay. And if you want to properly and appropriately assert Kansas jurisdiction based on post-trial circumstances, you'll need to file a new motion asking the court to do so. There has to be something that takes place between now and August the 29th where there's a proper request that would warrant the proper exercise of Kansas child custody jurisdiction. And it
Okay.
could be based on a California relinquishment at the end of this trial. If so, that needs to be put in the order that they are going to relinquish jurisdiction to Kansas for future proceedings. That it could be very simple. But
Okay.
you will need to do something to prompt reopening, essentially, of this case. It's going to remain open in a technical sense till August 29th. If nothing's filed, we'll review it at that point. If there's nothing filed that would warrant proper jurisdiction of the Kansas courts or bring a new matter before the court that's proper, then the court will just simply dismiss this case. So I
Okay.
think you misled.
So-
You are going to have to do something else.
Okay, so I will file motions in both California and Kansas. Judge Hamilton has made it crystal clear that she will not hear anything regarding jurisdiction as part of a custody hearing. She made me even so in the pending custody hearing, I filed all the necessary documentation and declarations to make the request for a change in jurisdiction as part of the current motion, and she refused to hear it and made me file a separate motion for that. Then heard the separate motion and turned around and said, I'm denying this because this other motion still exists. So we will finish with this motion. We'll finish with this motion. Whatever happens, happens. And then I will file both in California and in Kansas a request for a jurisdiction change. Assuming I'm basing that based on the assumption that the children's primary residence remains in Kansas.
Okay. Well, so that, once again, just so things are clear, the court will not be entering any orders today other than staying future proceedings in Kansas, leaving the case open until August 29 of 2025 to see if there would be some motion before this court or some new request for relief where we would properly exercise Kansas jurisdiction at that point. So that's where we're going to leave it today, and then we'll see what the outcome is in California. And if you feel that circumstances warrant some request to Kansas to leave this case open even further.
Thank you so much for your
All right.
time. I very
All
much
right.
appreciate it, Your Honor.
All right, very well. Then if there's nothing further at this time, the court will be entering a written order documenting what we've talked about here today. And that will be sent to both parties, obviously. And until then, the court grants a stay until August 29, 2025 for further review by the court to see if the case will stay open. Very well.
That's good.
Then if there's nothing further at this time, we will conclude this Zoom meeting for all participants.